Hearing the appeals, the Attorney General and another, and the General Legal Counsel and another against the Jamaican Bar Association.
Yes, we have a section headed housekeeping. Who is planning to be the lead housekeeper? As far as I'm concerned, we can go straight into submissions. Unless there's any point of about the timetable or anything that anyone wants to raise before we start. No? Good. Ms. White.
Good morning. My name is Lisa White. I appear along with Ms. Faith Hall for the Attorney General, the first appellant in this matter. And we take our submissions as read, my lords, and wish to highlight certain things before you. One of the things that we contend that the Court of Appeal got fundamentally wrong was the issue of the objective to be considered when applying the Oakes test as to whether or not the legislation under consideration is demonstrably justifiable in a free and democratic society. What we wish to underscore for this honorable court is that the reason for this regime is national security. And to just further break that down for your lordships, why was this regime required? Why was it drafted? In effect, the broad rubric is national security, but to break it down, it is managing the interaction between DFNI transactions and money laundering and or terrorist financing. And to further break that down, it is for the prevention, the reduction, and the detection of money laundering and terrorism financing on the one hand, and on the other hand, it is the protection of DFNIs from being conduits of money laundering and terrorism financing. Attorneys form but one group of DFNIs, given that there were different orders promulgated in respect of other DFNIs. The legislation as it concerns proceeds of crime, the Proceeds of Crime Act, the regime, does not particularize one group of business owners over another group. Therefore, calling into question this regime, my lords, has implications for the other DFNIs. And we will get to the discussion on the legal professional privilege point, but we wish to underscore that the objective is of great interest and is of great import concerning the nation of Jamaica.
Sorry, DNFIs is what?
Designated non-financial institutions.
Thank you.
So to achieve the objective, my lords, the government of Jamaica is targeting criminals. The government of Jamaica is targeting criminal property. The government of Jamaica is targeting criminality and the facilitation of criminal activity. The government of Jamaica is not targeting attorneys. And the regime is designed to suppress crime. The prevention, the detection, the reduction of instances of money laundering and terrorism financing. The regime is designed to combat and counteract money laundering activities, which are increasingly prolific, unfortunately, within the globe and Jamaica as well. The government is therefore, having promulgated this regime, playing its part to, from a global perspective, to stymie the risk of attorneys being used to facilitate money laundering activities. And it is quite clear, my lords, when one looks at the history of the development of the legislation and what we now call the regime. I will not propose to read for your lordships, but refer you to paragraphs 10 to 34 of our submissions, which you may find from page 1858 to 1862 of the bundle. There is an abundance of evidence before this court, my lords, about the government's international obligations in relation to anti-money laundering and counter-terrorism financing. And it is undisputed that money laundering activities are a matter of concern for the government and Jamaica as a whole, as borne out by the national security policy. And we direct you to the affidavit of Robin Sykes at page 713 of the bundle.
713, did you say?
Yes, my lord. 713. And the security policy from pages 1690 to 1838 of the bundle. And of note, my lords, is the observation that attorneys could become a tier 1 threat in the context of money laundering.
Where are you reading now?
I'm not reading, my lord.
I beg your pardon.
Were our activities to not be appropriately regulated as it concerns money laundering and terrorism financing.
So
The government had a duty in the context of increasing criminality to create a solution that would help to strengthen Jamaica's anti-money laundering and counter-terrorism financing policies. And the government would have had in its contemplation what had happened in another jurisdiction within the Caribbean, demonstrating the consequences of not instituting a rigorous enough regime to counter money laundering and terrorism financing within our nation. And this is outlined, my lords, at paragraph 25 of the affidavit of Robin Sykes, which you will find at page 720 of the bundle. So we wish to underscore for this honorable court that the government's implementation of the regime was critical, and for the regime to remain is critical. It is our submission that the Court of Appeal fell into error by not appreciating the objective of the regime and not giving sufficient regard to the history of the development of the law as submitted before it, as well as the relevant national context in which the regime is to operate and the circumstances which necessitate the passing of the regime. And we advance that the full court had a better appreciation for that context and why the legislation, the regime, is necessary. From as far back as 1994, my lords, Jamaica began the journey of legislative agenda that has led to the regime that we know today. That is almost 30 years of legislation. When one looks at the history of the development of the law, initially it started out with just forfeiture of property upon conviction for particularly prescribed offenses. So it wasn't just anything at all. And this was in 1994 under the Drug Offenses Forfeiture of Property Act. And then in 1996, there was the Money Laundering Act. I crave your lordship's indulgence. As this is by way of historical reference, some of these are not in the bundle, but it's just to chart the path for your lordships, for you to appreciate that this was not a sudden decision by the government. And the Money Laundering Act was passed in 1996, creating the offense of money laundering. And thereafter, the Money Laundering Act went through different iterations from 1997 to 2002. And eventually, the Proceeds of Crime Act was passed in 2007. The government initially targeted only specific offenses, and it is only upon conviction that forfeiture was possible. Thereafter, the government started to look at minimum transaction amounts, extending the transaction amounts, even designating, for example, remittances and non-traditional institutions as financial institutions for the purpose of reporting and monitoring the transactions to stem money laundering and terrorism financing. So what has happened is that over the years of development of the legislation to the regime as we know it today, the government has sought to, in more effective ways, to have specific legislation to address the issue of money laundering. So it is not merely looking at certain offenses, which was the previous dispensation, which was found to be limited. It's not just certain offenses, and it's not only in respect of convictions. What the regime shows is that once there is guilty property or criminal property, and there is established a link between this property and money laundering or terrorism financing, then there is provision for that to be dealt with. So it is not necessarily targeting a specific group of individuals per se, but it's to the extent that there is interaction between transactions and money laundering that the government is seeking to target these transactions. So to the extent that the transactions involve attorneys, then the transactions are targeted, because the transactions that intersect with money laundering, that's the focus of the government, not attorneys per se, because attorneys are but one of the designated non-financial institutions. The regime applies to all, save and except the specific pieces of legislation that are for attorneys. For example, the order that was passed in 2013 and came into effect in 2014. As it concerns attorneys, attorneys have always, as officers of the court, had to ensure that there is compliance with the law. The regime is only ensuring that continues. This duty to observe the law is no different, for example, were counsel to find himself or herself in the middle of a criminal trial and the client indicates that he committed the crime and there is no available defense. Counsel cannot reasonably make up a defense. Counsel may encourage his or her client to plead guilty or withdraw or may say they're putting the prosecution to proof, but counsel cannot proceed as if he or she were not in possession of that information. That duty to uphold the law continues, and to the extent that within the specific narrow circumstances where an attorney is assisting with a transaction that could be related to money laundering or could be designated as money laundering or terrorism financing, then the regime is very specific and the objective is being realized. Some may contend that it really affects everything that the attorney is doing. But on a careful reading of the Act and a careful reading of the provisions of the regime, it is clear, and particularly in the context where the General Legal Counsel has only identified 6 types of transactions out of the realm of activities that an attorney can do. It is clear that it is a very pointed regime, and when you look at the development of the law and the objective of the regime, it is really national security in the context of suppressing money laundering and terrorism financing. And in protecting counsel from being unwitting conduits or facilitators of money laundering or terrorism financing, the duty of counsel as officers of the court to uphold the rule of law is undergirded in the regime, and the protection of legal professional privilege is also contemplated explicitly by the regime. And in the circumstances, we contend and submit to this honorable court that it is very important to examine and interpret the regime against the background of the development of the law, the circumstances that give rise to the necessity for the regime, the mischief of money laundering that the regime is designed to combat, and the duty of counsel as officers of the court to uphold the rule of law and participate in, and not participate in or facilitate criminality or the legitimization of criminal property. We submit, therefore, that there is a good reason and justification for the implementation and the maintenance of the regime, and the objective thereof is clear and with merit. We submit to you that the full court, as compared to the Court of Appeal, the full court's view of the objective and appreciation of the objective is to be preferred to that of the Court of Appeals. And we ask this honorable court to bear in mind when construing and looking at the regime and all of the arguments that you will hear, to remember the background, the root of the regime, why it is necessary, why it was necessary in the first place, how the law has changed because of how the mischief has changed and evolved, and bear that in mind when assessing all the material before your lordships. Also, to bear that in mind when considering the issue of legal professional privilege. The full court was very forensic in looking at legal professional privilege and seeking to, by way of distillation, differentiate between those activities in which attorneys take part that would be covered by legal professional privilege and those that would be not within the context of the regime. The Court of Appeal found that the regime does not go far enough to protect legal professional privilege and the right to privacy. We respectfully disagree with this assessment and assert that the order that was promulgated in 2013 with effect in June 2014 is very specific as to the areas to be covered. The regime is specific in identifying the areas of risk and the areas which merit the treatment proposed by the regime. The 6 areas, if I may state them for this honorable court, include purchasing or selling.
It would help to have a page on which there are numerous pages where they're listed, but just
very
one
well,
in front of
very
us
well,
would be useful.
Page 1862 of the bundle.
Thank you.
At paragraph 31.
So can I just be clear as to your overall plan for your submission? So far you've given us, as I understand it, the background
Yes,
that you
my lord.
wanted to give. Are we now moving on to the issue of legal professional privilege?
Yes, my lord.
As a specific issue?
Yes, my lord.
Have you at this point got other specific issues that you're going to come to after legal professional privilege?
Yes, my lord. In relation to liberty and the search and seizure.
Liberty and search and seizure?
Yes, my lord.
Thank you very much.
We've got specified activities in paragraph 31.
Yes, my lord. Right. So the specified activities are purchasing or selling real estate, managing money, securities, or other assets, managing bank accounts or savings accounts or securities accounts, organizing contributions for the creation, operation, or management of companies, creating, operating, or managing a legal person or legal arrangement like a trust or a settlement, or purchasing or selling a business entity. The full court, unlike the Court of Appeal, made a distinction between instances where where legal professional privilege would apply, where there is giving of legal advice and so on, versus a transaction, assisting in a transaction. And as it concerns the 6 specific areas, these concern various transactions that admittedly do not always exclusively, or maybe never exclusively, involve attorneys alone. But the Court of Appeal, unlike the full court, looked at legal professional privilege as covering everything that the attorney does.
Well, the full court seemed to think that really none of these 6 types of activity was likely, typically, to engage legal professional privilege, and it would only be quite unusual for it to do so. I think that's a fair summary of the full court's approach to these transactions,
yes, it
these
is.
types of business. I've had, I must say, some difficulty with that. If the relevant test is whether the attorney should be looking at matters through his legal spectacles and giving advice to a client as and when he thinks the client, or he or she thinks the client needs it. Just to take, for example, purchasing or selling a business entity. And the sale of a business will require quite a sophisticated, or may require quite a sophisticated form of contract. It may require it to be negotiated in considerable detail between the parties, and it may require the attorney to advise the attorney's client, the seller of the business, let's say, or for that matter, the buyer of the business, about a number of legal aspects, legal risks, legal opportunities, which would arise in the negotiation of the transaction. I'm just wondering how in that, whether I misunderstood that context in the Jamaican environment, because I appreciate we're here talking specifically and exclusively about Jamaica, or whether some rather narrower approach to what legal professional privilege is all about is at play here. I mean, I could go through the whole list, but the other one that struck me as likely often to require legal advice is purchasing or selling real estate, because of the notorious difficulties about title, for example.
We're only concerned with these activities so far as they involve the attorney.
Yes.
Pardon me, Lord?
We're only concerned with these activities so far as they involve the attorney.
Yes.
Yeah.
So there is no other activity that has been identified by the order, which you may find at page 2394 of the bundle. I understand my Lord Briggs's question, but I think the full court was looking at whether or not there was any relevant legal context in what counsel is doing. And it is fair that depending on what is happening, admittedly the legislation cannot prescribe for every possible eventuality. But generally, as it concerns these activities, if it is that within the context of these activities, there is no relevant legal context, I understand the full court to be saying that legal professional privilege would not apply in those circumstances. I don't understand the full court to be saying that it could never ever apply.
No, they didn't go that far.
Right, they didn't go that far, and I don't think they could have gone that far. But I think what the full court sought to do was to differentiate between those instances where there is some relevant legal context, as your Lordship had said, where counsel may be advising on rights, liabilities, opportunities, etc., obligations, and other instances where there may not be any necessity for that. But in any event, it is within the context of this transaction. But what should be borne in mind, even if one disagrees with the formulation of the full court, is that the full court was correct. If you disagree with the formulation of the full court as to legal professional privilege, the full court was correct as it concerns the objective of the legislation, which is to target the transaction and not the privilege of counsel, or the privilege of counsel would not be displaced by the regime, because the regime is essentially targeting where there is intersection between the transaction and money laundering. And in any event, what the full court went on to opine is that where there is any criminality involved, say for example, what your Lordship has posited just now, there is some intersection with criminality. There is something where it could be linked to money laundering, or it could be money laundering, then it would fall under the exception. And that is how the full court reasoned it. Even if one were to say that the full court was too strict in its, or too narrow in its interpretation of legal professional privilege, certainly the full court would have balanced itself by recognizing that where legal professional privilege does apply, it is only where there is an exception of criminality that counsel could not rely on that to say, well, I'm covered by privilege.
So it doesn't matter for the purposes of your submission whether the full court was correct to say that legal professional privilege rarely arises in these 6 categories or arises more often. You would say in any event the regime still satisfies what is required to protect legal professional privilege.
Yes, it does. Yes, it does. And even if one were to be taking a liberal approach to legal professional privilege to say it covers everything, where I believe the court is correct, the full court is correct, is that once there is any whiff of criminality, once there is any knowledge or belief as it concerns the transaction being linked to money laundering or terrorism financing, that counsel cannot pray in aid privilege to resist the disclosure or whatever other duty arises under the regime. That counsel has a duty when coming into this knowledge or having assessed, as we are trained to do, assess the situation, assess the facts, assess what is presented, to then make a determination as to whether or not this is a transaction, be it purchasing, selling real estate, dealing with securities, whatever it is, that there is any hint of criminality, or if this could be criminal property that counsel is dealing with, remembering that the objective of the legislation in relation to national security is targeting criminal property and not targeting counsel. It is for all designated non-financial institutions to make that determination when presented with the facts as to whether or not they need to make a disclosure to the competent authority. And attorneys are no different in that regard. Yes, there is privilege. And yes, it could be argued that this attorney-client relationship may not necessarily compare with one or other of the designated non-financial institutions. But where all receive equal treatment before the law is where all are required under the regime to be mindful of the types of transactions, the context of the transactions, the behaviors of their clients, if there is any unusual behavior, to note in whether there are large amounts of cash involved, that there must be some regulation in relation to the intersection between the transactions and money laundering or terrorism financing. For the attorneys, as promulgated in the order, these 6 types of transactions have been identified out of the number of transactions that attorneys admittedly perform on behalf of our clients on a daily basis. So even in terms of what has been identified compared to what has been omitted, it is submitted that the full court is correct It is submitted that the full court is correct in its treatment of these 6 areas.
Well, you would accept, would you, that if someone goes to an attorney in Jamaica to set up a trust or a settlement, that will almost inevitably involve the giving of legal advice?
Yes, it would.
I'm just looking at some of these categories. On the face of it, that would be a relevant legal context for privilege to arise.
Yes, my lord.
Yes. Can you help me for a moment with D, which is organising contributions for the creation, operation or management of companies? Does that mean money contributions? Is it raising finance? I'm just not quite sure I understand what activity that captures.
It could involve raising funds for the establishment of a company, or
It is fundraising.
or
Yeah.
monetization, perhaps using the stock market.
Yes, thank you.
Even if your lordships prefers the Court of Appeal's formulation of legal professional privilege, the regime, explicit in the regime, is a protection and identification and recognition of privilege. There are safeguards, my lord. When one looks at, for example, Section 94 of the regime and 91A and Section 91A of the regime, of the Proceeds of Crime Act.
Could you just give us the page references, please, when you... Electronic bundle.
I crave your lordship's indulgence.
You have access.
But you have to find it. Well, it's, the act is between page 2190 and 2355, and we will give you the specific page for section 94.
The 2295, is it? You're after section 94?
Yes, my lord. Yes, 2295, and section 91A is on, it starts on page 2290. Section 91A, subsection 3, Section 94, subsection 5B, and Section 94, subsection 8 explicitly reference legal professional privilege, my lords. Counsel are only required to produce documents that are non-privileged. The regime targeting criminality is not interested in these in the privileged aspects of the practice. What is important is the criminal property and the identification of same. So when one looks at section 91A3, 94.5b, and 94.8, it is clear that the government gave due consideration to legal professional privilege. The regime therefore does not require counsel to break that confidence. The regime requires counsel in his or her duty to uphold the law, to comply with the regime to the extent that there are transactions which touch and concern money laundering or terrorism financing. That is what the full court sought to observe, and that is what the Court of Appeal did not fully appreciate with respect.
So the submission is that these provisions that you've pointed us to are a protection for attorneys by effectively, statutorily codifying, if you like, legal professional privilege.
Yes, my lord, in the context of the regime. In the circumstances, therefore, it is not necessary for the legislation to be very prescriptive, detailing every possible permutation that could occur. And not going into great detail as to how and when privilege could be relied upon by counsel does not render the legislation unconstitutional.
Because they can recognise the situation in which professional privilege will arise and invoke it.
We hope so, my lord, because you may have one instance where you're setting up a trust, for example, and it may be complex, for want of a better word, and you might have another trust that does not involve as many considerations. Or you may have an issue where they're setting up the company and it's a simple question of the source of the funds, where in one instance it can be readily explained and in another there are some issues that arise. So on each occasion, counsel has to look at the circumstances with which he or she is presented and make a determination. It is not sufficient for counsel to just say, oh, you know, it's just covered by privilege. We need to exercise our minds and assess the situation, ask the correct questions as required, given how sometimes it is so insidious, the detection of money laundering and how it presents. Still at the same time, bearing in mind the issue of privilege, which is not contravened by the regime in any way.
So if the attorney thinks it's a difficult question, what does he then do?
Well, the attorney needs to see if there is enough evidence that would cause him or her to know or believe that it could be related to laundering, or it could be money laundering, or if it's not as high as that, they would have to determine whether or not there are reasonable grounds to determine whether or not the reasonable grounds to know or believe that's the situation. And in terms of,
I think the point of my Lord's question may have been, if it's a difficult question, whether the way in which that information came to the solicitor was privileged or not. So suppose that the attorney thinks he has reasonable grounds for belief that a relevant wrong has been, that money laundering is going on, but he's not obliged to disclose that if he only learnt that through privileged material, and it's a difficult question for him whether it is or isn't privileged. What does he do in that situation?
if it is that he is not certain or she is not certain, then that person can take legal advice. And we must always remember that in instances where privilege applies, but there is some hint of criminality, privilege would not protect counsel at that point. There is this duty, because if it is that counsel is aware that there is some money laundering or terrorism financing involved, but to resolve the difficulty, counsel can take legal advice.
Can he
And
go to
in
court?
those
Can he raise the matter with the judge?
It's possible if it is that the matter were before the court. It could be possible, but as a first step, perhaps counsel could take advice in circumstances where he or she, when they're taking advice, it would itself be privileged. And thereby that counsel would be protected, and it would not be an unmeritorious disclosure in those circumstances.
Is there protection expressly provided in the legislation for the attorney who reasonably comes to the wrong decision about whether the information is privileged? So he does suspect that there is money laundering going on. He thinks that the information which he would otherwise have to disclose may well be privileged. He takes advice. He's told, yes, it probably is privileged. He doesn't disclose it, but he's wrong. What protection for him is there then? I suppose you might rely on subsection 5A. Subsection 5A, he has a reasonable excuse for not disclosing the information or other matter.
That is what I was looking for, my Lord.
Okay,
That's 94.5A. Because when you look at the legislation, especially the aspect of it that talks about reasonableness, counsel needs to satisfy him or herself in two respects, objectively and subjectively. Subjectively, as your Lordship Richards has said, counsel may have an honest belief and may have a suspicion, a gut feeling, if you will, that something is amiss. may have, but counsel to satisfy the reasonableness requirement must have some grounds outside of this mere suspicion. If it is that whatever presents as objective grounds, as in the example that your lordship gave, whatever has presented is not sufficient in counsel's estimation, notwithstanding the honest belief that he should disclose, and he doesn't, then he or she could argue that there is a reasonable excuse.
Yes.
But what is clear is that it really is a very nuanced situation for counsel to make that determination based on the facts that are presenting at that time. And in recognition of the nuanced situation, the regime makes provision for the safeguards. For example, the JLC set up hotline, and if he's invoking privilege as protection for him or her in that situation.
Have you got a particular provision in mind there?
Pardon, my lord?
Have you got a particular provision in mind there?
There's section 94, subsection 4, which is at page 2,295 of the bundle. I'm sorry, my lords, it's 94 subsection 5A.
Yes.
On page 2,296 of the bundle. And also 94 subsection 5B in relation to the attorney at law invoking privilege in the circumstances.
So I think what I was suggesting was that if the attorney came to the wrong conclusion about privilege, he thought it was privileged, but it's later found that it wasn't. But if he'd acted reasonably, he could he'd have a defence under 5A that he had a reasonable excuse.
That is so, my lord.
That's your
If
solution.
he or she can show the steps that were taken
Yes.
to arrive at the decision, given that there is no situation that is absolute.
Yes.
And of course, counsel would have to make a determination on a case-by-case basis.
Is there relevant guidance, as referred to in subsection 7A1, on this question?
Yes, my lord. We were just about to refer you to subsection 7A1. And in that, the JLC makes provision for the hotline and the guidance notes.
Where do we find that?
7,000, page 7,084. Please see paragraphs 15 and 16, my lords, which you will find at Yes, yes, my lord. $7,095 at the top of the page. That I'm not seeing properly.
So I'm not quite sure where I see a hotline.
The hotline was not specifically stated in the legislation, my lords. It was a practical matter that was set up by the General Legal Counsel. Counsel calling anonymously.
But there's nothing more specific than this in terms of guidance falling within section 94, subsection 7. There's been nothing more specific.
No, no. What is clear, my lords, is that when you look at the regime and come looking at that with paragraphs 15 and 16 of the guidance notes, it may not specifically set out in more detail protections, but certainly counsel can seek to create a legal professional privilege, and counsel can seek to take the appropriate steps when assessing a situation, given the fact that one situation may call for more rigorous action than another situation. But at all times, privilege may be prayed in aid. So again, it is for counsel to assess the situation, because the legislation cannot make provision for all possible eventualities. But the overarching framework is there. And we also would need to recall that the regime generally is stated in general terms to refer to all designated non-financial institutions, of which attorneys are but one. There is not a separate primary act that is for, say, for example, public accountants or casino entrepreneurs. All designated non-financial institutions must refer to the Proceeds of Crime Act. And to the extent that sections 94 and 91A explicitly recognize legal professional privilege, it is provided for in the Act. But if it is that your lordships are of the view that the legislation needs more specificity, that in and of itself does not make the regime unconstitutional.
Yeah, I think I lost this already. I think I did it with 18 and 19. Okay.
If your lordships have no further questions in relation to privilege, we would wish to address you on the issue of liberty. In relation to the issue of liberty, my lords, we advance to this honorable court that the formulation by the full court is to be preferred to that of the Court of Appeal. The Court of Appeal was more expansive, if you will, in relation to liberty and fell into error as it concerns construing what the Constitution provides for. Of note is that the Court of Appeal looked at the potential for the deprivation of liberty, postulating that that should stand on its own as opposed to the the threat to the deprivation of liberty to stand on its own as opposed to the actual deprivation or physical constraint on a person without that person's consent. We submit that the full court, in restraining itself to what is actually in the text of the Constitution, which contemplates the restraint of physical liberty, was correct.
Thank you.
The Court of Appeal, we submit, was more persuaded by the Canadian framework. The full court was more persuaded by the framework from the European Court of Human Rights. Article 5, we submit, of the European Convention on Human Rights is closer in text and meaning to the provisions of the Jamaican Constitution. Article 5 you will find at page $2,651 of the bundle.
Yes, thank you.
How can I not get this wrong one? Okay.
You can find that for me. No, it's not on there. I'll just go right here. And when one looks at Article 5 and compares it to Section 13 of the Constitution, which you'll find at page 13.3a, at page 2011.
2011.
Yes, my lord. You'll see that what is contemplated is a restriction on the freedom of the person without the person's consent. So Article 5.1 states that everyone has a right to liberty and security of person. No one shall be deprived of his liberty save in the following cases and in accordance with a procedure prescribed by law, including the lawful detention of a person after conviction by a competent court. Article 5.1a. And in Section 13.3a of the Jamaican Constitution, it speaks to the rights and freedoms referred to in subsection 2 include the right to life, liberty, and security of the person, and the right not to be deprived thereof except in the execution of the sentence of a court in respect of a criminal offense of which the person has been convicted. When one examines the regime, it is clear that what is contemplated is for any liberty to be infringed upon only after a conviction. And the full court appreciated that. The Court of Appeal seemed to make a distinction between the threat to the deprivation of liberty as compared to the actual deprivation upon conviction, and I would add sentencing. The scheme of the regime only provides for possible infringement on liberty where there is a conviction.
So if you're held on remand...
Pardon, my lord.
If you're held on remand, you say that's not an infringement of the right of liberty?
I'm not saying that, my lord, but that is a part of the prosecutorial process. One has to make a distinction between what may obtain in the prosecutorial process as opposed to what arises in what implications there are for liberty upon conviction. Admittedly, there are several offenses created by way of statute in Jamaica, and the general prescription is if a person does X or fails to do Y, that person commits an offense, and upon conviction before a parish judge or a circuit court judge may be fined or imprisoned or both. The legislation, and we have to look at what is written in the legislation, prescribes the punishment upon conviction. In the prosecutorial process, it is true that a person may be remanded for various reasons. A defendant may not come to court, a bench warrant is issued. But or there is due process, and in any event, that is not to be subsumed under the sentencing provision of the Act. When you're looking at the legislation is not prescribing detention, remand, or imprisonment during the prosecutorial process. The legislation is prescribing as a possible punishment, because in some instances there can be a fine, that it is upon conviction, not upon being charged or even arraigned, or even during the trial process. So it is where the person is submitted to a competent court of law with the requisite jurisdiction, and that court of law finds that the person is guilty and the person is convicted. It is at that time that the right is engaged, not before. So in the context where the Constitution contemplates physical deprivation and not the threat of deprivation, we must construe the Constitution as written and not read into it provisions which are not there, which is exactly what the Court of Appeal has done. Due process is provided for in the Constitution itself, and the Constitution is clear that the rights are not absolute, and to the extent that one may be detained, it can be done pursuant to a sentence from a competent court of law. What the Court of Appeal did, my lords, is to impose or cloak the Constitution of Jamaica with the judicial interpretation from Canada when it is not. It's not commensurate. We would have to remind ourselves that in Canada, they must consider fundamental justice, which is not written in our Constitution. In Canada, they must consider reasonableness, which is not in our Constitution, in Jamaica's Constitution. And they must also consider demonstrable justifiability. So, admittedly, when the court is assessing a piece of legislation in Canada, they must assess it bearing in mind these three things. In Jamaica, what is to be considered is whether or not there is any infringement, and if so, whether or not it is demonstrably justifiable in the circumstances. So if one were to just merely lift the Canadian cases and plant them in the Jamaican context, there is not a proper fit at all. We urge this honorable court to consider the opinion of the European Court of Human Rights as correct, and we posit that what is contemplated in Jamaica is the physical restraint and not the threat of deprivation. Otherwise, what implication could that have for the myriad pieces of legislation that statutorily prescribe offenses in Jamaica? Could any litigant under the Offenses Against the Person Act, the Sexual Offences Act, the Offensive Weapons Prohibition Act, say that that they have a right to
Constitutional right to liberty has been breached.
The constitutional right to liberty has been breached because there is a threat to the deprivation of liberty? We submit no, my lord. And so the Court of Appeal's interpretation of liberty, first of all, seeking to create some division between the threat to liberty and the right to liberty as freestanding and separate, not a correct formulation. And secondly, to import a standard which does not fit properly within the Jamaican context. Those are two areas in which the Court of Appeal fell into error. And we submit, my lords, that the full court's formulation is preferable in the circumstances as to what actually obtains in relation to the issue of liberty.
Do you by any chance have the references to the particular paragraphs of the two judgments that you've got in mind, just so that we can have a quick
Very well, my lord.
refresh our memories, or now or later?
Might we give you later, my lord?
No, paragraph 276.
This is which one?
The full court.
In full court, my lord, from paragraph 276.
276?
Yes, my lord. To the paragraph.
That's a paragraph.
Pages 215.
It's a paragraph.
It's paragraph. Page 215 of the bundle, my lord, where you will find paragraph 276 of the full court's. What about Justice McDonald Bishop?
Yes.
The page, paragraph 276 onwards for the full court, my lord, and for the Court of Appeal.
Of the bundle. Page, the bundle, the page number of the bundle.
Yes,
Yeah,
it's
it's
page 332. Yes,
The 600.
Yeah, but you have to.
You want the paragraph number?
In the Court of Appeal, my lord,
Page 332, which can be found at 332.
it is paragraph 307 onwards.
Sorry, paragraph?
Which is 307. 307.
307, yep.
To 363. At page
332. Starting at 332.
No, it's not 322. Paragraph 307.
I'm not sure that was the right page number.
Page 479, starting at page 479 of the bundle, my lords.
Yeah.
This is, I don't know if you want to read it or leave it at that.
Yeah. No, hold on. Section 14.
And you arrive at that conclusion based on the wording that you've shown us, the difference in wording.
Yes, my lord.
Yeah.
But also the principles that are to be accounted for by a court of competent jurisdiction in Canada are not in our constitution at all, in terms of the principle of fundamental justice, as well as, which is a qualifier for their rights, as well as the issue as it concerns reasonableness that is expressly provided for in the Constitution. So when looking at whether or not the rights have been engaged or whether or not it is demonstrably justifiable, the Canadian court necessarily must take into consideration these factors which are not present in the Jamaican Constitution and should not be used to create or splinter a right when that is not otherwise required.
What
Section,
Somebody can.
the Proceeds of Crime Act. Section 30, 2688. And when one looks at the scheme of the Act, my lords, and particularly in Part 5 of the Act, generally, one could even say probably more than 97% of the offenses contemplate the loss of liberty only upon conviction. And this is overall for the Act, and in Part 5, it is exclusively only upon conviction. I just want to show to your lordships the I crave your lordship's indulgence. Stuck in 31. Just to show them that is only okay.
Which one you're looking for?
You found it? Okay.
Just one.
Well, Lords, I will advance the page number shortly. But just to make the point, my lords, that as it concerns the general scheme of the Act, the regime contemplates loss of liberty only upon conviction for persons. And when one looks at the various offenses, not only those that are dealt with under Part 5, most of them, it's only in relation to conviction that the detention of a person is contemplated. It's only under Section 31, 1 and 3, subsections 1 and 3, that there is a differentiation between detention and imprisonment as it concerns the loss of liberty. The Act and the regime generally do not contemplate any threat of loss of liberty, and that should be the confines of the prosecutorial process and should not be read into the regime as has been done by the Court of Appeal.
Sorry, I'm just going to... the distinction between detention and conviction, where are you turning to for that?
There is only one place in the Proceeds of Crime Act where it makes a differentiation between detention and conviction.
Where is that?
So Section 31, subsections 1 and 3, where that is contemplated.
Can we just look at that?
Very well.
What page are we on, sorry?
I crave your lordship's indulgence.
2238.
2238.
Right. Thank you, my lord. 2238. In section 31(1), the differentiation between detention and imprisonment only arises in respect of the default in payment of a pecuniary penalty order. Otherwise, my lords, when one looks at the various provisions, including the ones in Part 5, the loss of liberty almost exclusively is in respect of imprisonment after conviction, and therefore it would not have been necessary for the Court of Appeal to consider any formulaic in relation to the threat of the deprivation of liberty. Because, first of all, it doesn't arise in Part 5, which is the relevant part, and second of all, based on the scheme of the regime, that is not what is contemplated. And thirdly, under the Constitution, what is contemplated is the physical deprivation of liberty and not the threat of physical deprivation.
What does detention mean in this 31(1) and 3?
That would be a temporary deprivation of liberty, but that is only in respect of a default in payment of the pecuniary penalty.
Yeah, what does that actually mean in practice?
Physical restraint.
How are you?
Would be physical restraint.
And what does that mean?
Being detained in a facility, a correctional facility for the state.
A what facility?
Correctional facility.
Is that something done pursuant to an order?
It would have to be an order, my lord.
That's due to a pecuniary order.
Because there would have been a pecuniary penalty order and the person would have defaulted on it.
So it's due to an order.
But it's not a prison.
It would be.
Sorry, I don't know what a correctional facility is. What is a correctional facility?
It is not for final imprisonment, but it is a detention center where persons are kept by the state on remand.
Thank you. But there are provisions in the Acts that dictate when these orders can be made and when detention can be imposed.
Yeah.
That's the only provision there, because if I might give your lordships a listing in the Act itself, every other instance where there is the contemplation of loss of liberty, it is only upon conviction. So even the scheme of the regime itself does not support or does not ground the assertion by the Court of Appeal that there is this notion of the threat to the deprivation of liberty. So we advance this, my lords, to demonstrate that the Court of Appeal would have been in error in seeking to infer what is not provided for in the legislation or the Constitution by formulating what it has been advanced by that court as the threat to the deprivation of liberty.
If you read right through to paragraph 350 of the Court of Appeals judgment, I'm on page 495, am I right in thinking that what they're really saying is that there's an unconstitutional deprivation of liberty because the offences may be committed in circumstances where there has been an unconstitutional loss of privacy, so that their conclusion that there's been a deprivation of liberty appears to be entirely based upon their previous conclusion that the regime wrongly interferes with privacy. Is that a fair
That is correct. That's correct, my lord.
And if that's right, how much help is a refined analysis about what liberty means going to advance us towards a conclusion of the appeal?
Very well, my lord. We were actually going there next, and I thank your lordship for that intervention, because our submission is that the court improperly twinned the right to privacy with the right to liberty. And the court improperly found that if there is any contravention as to the right to privacy, that it would necessarily mean that the right to liberty would necessarily be engaged. And this is in the context where there is no correlation in the text of the Constitution or otherwise between the right to privacy and the right to liberty. Because the regime only makes provision for imprisonment after due process, and it has not infringed on Section 13(3)(a) of the Constitution thereby. If it is that an attorney complies with the requirements under the Act, the attorney would not have committed an offense and would not be at risk of losing his or her liberty. The loss of liberty only arises on the face of the legislation in respect of conviction and is not in any way twinned with the loss of privacy as alleged.
Yes.
Yes, my lord. Might I crave your indulgence?
We are not accepting that there was a breach of the right to privacy. Yes, it has been infringed and not certainly justified in a democratic society. So we link with the I can link it back to the findings of the full court on the right to privacy.
They found that it is engaged. They found that it is engaged.
That it's not justified.
Okay. So, my lords, in relation to the finding of the Court of Appeal, it is our submission that the full court's formulation as to the right to privacy being engaged We do not have a quarrel with that, but we submit that it is demonstrably justifiable in a free and democratic society.
So you accept, as I understand it, that
The full court decision.
although you say there was no interference with legal professional privilege,
Yes.
there was an interference with the essentially private nature of the relations between an attorney and a client.
There could be an interference
And for
with
that purpose, you rely entirely on demonstrable justification.
Yes, my lord.
Yeah.
That's the argument. The Court of Appeal failed to appreciate that. That's why she fell in error when they twin it together.
And you accept, I think, don't you, that the essence of an attorney-client relationship is one of confidentiality.
Yes, my
So that
lord.
although legal professional privilege doesn't stretch right across the board, confidentiality does.
Yes, it does.
Yes.
And that is part of the reason why it is problematic for the Court of Appeal to twin the right to privacy with the right to liberty, because they don't necessarily flow one to the other. And that is why, my lord, we contend that the test as to demonstrable justifiability is critical for this matter.
Yes. And you're coming to that now?
Yes.
Good.
We will not recite what we had gone over earlier, my lord, in relation to the objective of the legislation, but just to submit to your lordships that the combined measures that we call the regime are not arbitrary in any way, as seen by the historical references that we made before your lordships this morning and how the law has developed over time. It's not arbitrary in that it has, from the very beginning in 1994, targeted criminal property, targeted criminality. And over time, in assessing the situation and being aware of how the mischief has evolved, the law has sought to combat that and to address it. And so we look at the measure and then the means by which the measure is to be upheld. And in the
Just before you get into that, can you help me on this? As I understand it, the extension of the DFNFI regulatory regime to attorneys was stopped by injunction right at the outset of these proceedings.
That is correct.
And that injunction presumably continued after the judgment of the full court, pending the appeal to the Court of Appeal.
Yes, my lord.
So as to protect the Bar Association's appeal. And it has continued since, has it? Or is it simply the effect of the Court of Appeal's order that has now, as it were, prevented it being extended?
Extended it pending judgment, and then they quashed it. My lords, the Court of Appeal extended the injunction pending delivery of judgment, and then thereafter they quashed
They simply quashed the provisions.
They quashed it.
So we're not under an injunction regime now, we're simply under a quashing of the provisions.
We are under a quashing order.
Yes. And my related question was, bearing in mind, as I understand it, your case that Jamaica was really under threat of international sanction, had little alternative but to make these changes and to extend the DNFI regime to attorneys.
That is so, my lord.
And has been unable to do so now for 8 years. Have there been any international sanctions imposed as a result of that hiatus?
There is we have a grey listing at the moment, my lord.
I'm sorry?
We have a grey listing at the moment.
You have a
Grey
Grey listing.
A grey listing, yes. And is that a grey listing, when was that imposed?
I'm not sure when it was imposed, my lord. I would have to find out that.
It would help if you'd be good enough. And in practice, is there some convenient document where the effect of a grey listing is spelt out in the papers so as not to waste your time having to explain it orally?
There's a mutual evaluation.
There is a mutual evaluation report, my lord, and I would have to check with the competent authority for
The latest.
CFATF as to the latest designation. But my understanding is that there is a grey listing for Jamaica.
If at some time you can give me a reference to a page number that spells out what the grey listing is in terms of its immediate consequences, that would be very helpful.
Well, I'm not sure that's the current situation now. I'm not sure if the papers would have that evidence for you, but Mr. Sykes's affidavit.
Well, on the assumption that the consequences of a grey listing are not, as it were, contentious, it would certainly help me at any rate to know what those consequences are.
I undertake to get the information to your lordships by tomorrow.
Perhaps you'd show it to the other parties first.
Pardon, my lord?
Perhaps you would show it to the other parties
Definitely,
first,
my lord.
if it involves the introduction of a new document.
Very well.
Thank you.
As we were going on, the affidavit would have outlined the international requirements and
the consequences. But in any event, my lord, we commit to your lordships the affidavit evidence sworn to by Mr. Robin Sykes, to be found at page 300.
I think it was around about page 713.
Page 713 of the bundle.
Yes, my lord.
Yes.
And the affidavit of Albert Stewart as well. But in particular for Mr. Sykes' affidavit, he underscores the importance of Jamaica's compliance with the FATF recommendations, Financial Action Task Force's recommendations, and the consequences of non-compliance. Excuse me. Sorry. So, my lords, in relation to the applicability of, the issue of demonstrably, the regime, being demonstrably justifiable in a free and democratic society, it is our submission that the regime is not arbitrary. And when one looks at the regime that it provides for and it relates to various designating non-financial institutions, including attorneys, it's not unfair in that regard. And when one looks at the order that was promulgated in 2013 that has only specified 6 types of transactions, and it shows it is also very specific and not irrational or unreasonable in the circumstances. Also, there is a very direct and rational connection between the objective and the regime. The objective being national security. And bearing legal professional privilege in mind, it is clear that there is as little as possible infringement in the circumstances where counsel is concerned. And when you weigh the objective with any infringement, it is our submission, my lords, and we ask you to bear in mind the public interest I crave your Lordship's indulgence. The public interest in stymieing money laundering in Jamaica. And from a national security point of view, the greater the interest, the greater the interference that may be allowed. And we rely on the case of Suraj at paragraph 91 in this regard, my lord. And I will give you the page number of the bundle. But until I give you the page number, my lords, we just wish to underscore that when one considers the issue of demonstrable justifiability, that the regime...
I think it's 6643.
But you accept this involves a proportionality assessment?
Yes, my lord. And there is proportionality, my lord, between the effects of the measures and the objective identified, which we submit to you is of sufficient importance in the circumstances. The action that has been taken by the regime, my lords, if you find that there is limitation on any right, we submit that it is as least or as little as is reasonable, as is possible, to achieve or protect the objective of national security. And there are no alternative means of achieving the objective. And this is in the context where, from the beginning, you had different types of businesses that needed to report to the respective competent authority. So the scheme of the legislation generally has not changed, and the means by which there is enforcement has not changed. What has changed is the increase of the number of entities, business entities, to which it is now applicable. So there is a broadening of the reach of the legislation, but not a change in the nature of the legislation, where from the very beginning, in 1994, the government has been, through successive iterations or different pieces of legislation, sought to target criminality and crime and the effects of money laundering and money laundering itself.
Some infringement based on the objective, it is justifiable.
This is it. I don't have anything else to say.
No. Okay. After your time.
Okay. So, my lords,
The mechanism is the mechanism in the regime. In the regime, infringer as little as possible.
if it is that your lordships find that there is any infringement, it is our submission that there is as little as possible any infringement. And when one applies the proportionality test and balances the objective of the regime with the infringement, it is our submission that the regime is not to be found as unconstitutional in that regard, my lords. If your lordships have no further questions, that would be the end of my submissions.
No, thank you very much.
Very well.
Mr. Wood.
May it please you, my lords. In making our present submissions, we would, without trying to repeat what my learned friend has said for the first appellant, we would have a look at what we consider to be the interpretation of the Constitution, the interpretation of the relevant provisions of section of the Proceeds of Crime Act, which is section 91A, dealing with inspections by the General Legal Counsel as competent authority. And we would also touch upon sections 94 and 95, which deal with disclosures by the attorney, and move into what we submit as the relevant provisions of the guidance, and a few brief remarks without repeating my friend on proportionality. In the respondent's case, in the appellant's case, we had at paragraph 14 set out the relevant provisions of relevant principles of interpretation of the Constitution.
Do you have an LA page for that? But I know you're using it in separate paper.
That runs from page 1924 over to 1926.
Thank you.
And without repeating, we adopt that submission. The respondent took issue with subparagraph 14I, where one of the principles extracted was stated to be where it is contended that an enacted law is incompatible with the Constitution, the court's duty remains one of interpretation. If there is an issue about the meaning of the enacted law, the court must first resolve that issue, and having done so, it must interpret the Constitution to decide whether the enacted law is incompatible or not. That principle was taken from the recent decision of this board in Day versus Government of Cayman, and the board, in stating that principle, relied on an earlier decision in Reyes versus the Queen, and that is in Day, it is at paragraphs 35 to 36, page 3831. If I could just read the extract, it's taken from a speech of Lord Bingham in Reyes versus the Queen, quote, "When as here an enacted law is said to be incompatible with a right protected by the Constitution, the court's duty remains one of interpretation. If there is an issue as here there is not, about the meaning of the enacted law, the court must first resolve that issue. Having done so, it must interpret the Constitution to decide whether the enacted law is incompatible or not. Decided cases around the world have been a valuable guidance on the proper approach of the courts to the task of constitutional interpretation, and there's a citation of cases from a number of jurisdictions, including the United States. It is unnecessary to cite these authorities at length because the principles are clear. As in the case of any other instrument, the court must begin its task of constitutional interpretation by carefully considering the language of the Constitution. And it goes on. I believe it also makes the point that the judge should not, in the course of interpretation, impose their own moral values and predilections. They must look at the language of the constitutional provision. In reviewing the judgment of the full court, the Court of Appeal found numerous errors in the full court's judgment, including an error as to the application of the burden of proof. And it was those errors that they found enabled them to determine the issue of proportionality de novo. We submit there were no errors when the full court's judgment is properly read, and we submit that the full court was correct. One of the errors, and noted by the Court of Appeal, was that the full court went out of its way to apply a presumption of legality in the interpretation of the Proceeds of Crime Act to validate, they say, the power conferred on the General Legal Counsel by POCA. And that, I think, appears at page 513, paragraphs 406 to 410. Page 513, paragraph 406 to 410, I believe they talked about the court, yes, the full court validating the power. There was no validation of the power. What the full court did was to interpret the power to assess the scale of interference. But it was always accepted that the regime interfered with the right of privacy and interfered with the rights given by Section 13(3)(j). The Court of Appeal also found that the full court erred in placing a burden on the appellant to rebut the presumption of constitutionality and to do so beyond reasonable doubt. And that appears at paragraph 137, page 406. Again, there was no such error made by the full court, and it is, we respectfully submit, an incorrect reading of the judgment. What the full court did is that they considered the burden that existed prior to the amendment of the Constitution to introduce the Charter in 2011. And then from page 126, they discussed the change that was effected by the Charter. And over at page 129 to 130, you will see that they expressly adopted a analysis from a work by Butler, which is commended itself, that is on the proportionality test, and they adopted and they stated that this was compatible with the submissions made by the second defendant, the GLC, citing a case out of New Zealand on proportionality, retrofit versus Telecommunications of Jamaica. Telecommunications Corporation, I'm sorry. The error by the Court of Appeal in stating that the full court applied a burden or imposed a burden on the claimant beyond reasonable doubt is stark when one goes further to see how the full court commenced their analysis of proportionality at paragraph 359, page 248. And I just read that. The rights guaranteed by Section 13 of the Charter are not absolute. When assessing an apparent derogation caused by statute using the Hines test, the starting point is always the presumption of constitutionality and that the legislation is reasonably required. The new Charter, however, has incorporated the terminology demonstrably justified as a measure to determine constitutionality when a breach of a fundamental right is alleged. In Regina versus Oaks, which explained how the test should be applied, the Supreme Court of Canada outlined that a claimant merely needs to show that prima facie the statute infringes one or more of the fundamental rights provided for under the Charter, and upon the alleged infringement being established, the defendant must show that the infringement is demonstrably justified in order for the impugned legislation or action to be upheld. To be upheld as constitutional. We have found, as submitted by the claimant, that the Charter rights of privacy members of the Claimant Association under Section 13(3)(j)(2), protection of private life, which includes professional life, and 3, protection of communication, have in fact been interfered with. Following the test in Oaks, in order to establish that a limit is reasonable and demonstrably justified in a free and democratic society, 2 central criteria must be satisfied. First, the objective which measures responsible for a limit on the Charter right or freedom are designed to serve must be of sufficient importance to warrant overriding a constitutionally protected right or freedom. It is necessary at a minimum that an objective relate to concerns which are pressing and substantial in a free and democratic society before it can be characterized as sufficiently important. And there follows their analysis and findings on the proportionality test. So it's incorrect for the Court of Appeal to have found that the wrong test was applied by the full court and that they put the respondent to prove beyond reasonable doubt. Further, as we had previously stated, the full court did not validate the powers given or conferred on the GLC by the Act. To the contrary, having interpreted the statutory provisions, the full court found there was interference, and at paragraph 360, page 249, the court reiterated that having found interference with rights of privacy of attorneys under section 13.3J2 and 3, it followed the Oakes test. The Court of Appeal, and we adopt my friends' submissions on how the Court of Appeal also treated with the liberty right. And we have dealt with that as well in our case to the board. They found that the full court erred in its interpretation of the ambit of the constitutional provisions of section 13.3a, the liberty right. In actual fact, the difference between the approach of the Court of Appeal and the full court turns on the interpretation of the ambit of the right stated in 13.3a, namely whether the section sets out one right or, as found by the Court of Appeal, separate and distinct rights. This is a problem with the Court of Appeal's decision. They found that section 13.3a sets out two separate and distinct rights, being the right to liberty as opposed to the right not to be deprived of liberty, which they stated to be a close sibling to section 14, which also deals with liberty, and which they then stated to be a triplet of rights. And that appears at paragraphs 311 to 12, page 480, and 329, paragraph 488. So at paragraph 311, for example, I read that, by focusing only on the right not to be deprived of liberty and the qualifier in section 13.3a, the full court excluded from its contemplation the simple and fundamental right to be free from impositions of one's personal liberty. One need not be deprived of one's liberty for there to be a violation or threatened violation of one's basic but fundamental right to be free from restraints. Hence, the need to view each right separately and distinctly from each other, albeit intertwined. Furthermore, the right to liberty and the right not to be deprived of it, guaranteed by section 13.3a, are in my view close siblings to the right to freedom of the person, which is protected in 13.3p, and 13.3p refers you to section 14, the liberty right. They may, in my view, be appropriately regarded as triplet liberty rights. And at paragraph 329, 488, accordingly the full court, in adopting the narrow sense of the word liberty, which was freedom from personal restraint as per the European Convention, the UN Charter as well. She says, accordingly, the full court, in adopting the narrow sense of the word liberty as meaning incarceration or physical restraint, ought to have construed section 13.3a by examination of the actual words used in that section, while having regard to the provisions of the Charter, read as a whole. Had the full court employed that broad and purposive approach, it would have recognized the two distinct liberty rights secured by section 13.3a, as well as the intimate connection between section 13.3a and sections 13.3p and 14, with the recognition that even more significant similarity between Article 5 of the Convention and the Charter would have become more evident. Similarly, the full court would have recognized that the Charter, in treating with liberty rights, is not as fundamentally different in terms and effect from Section 7 of the Canadian Charter as it had opined. This similarity arises from the fact that the specific qualifying section 14 of the Charter, except on reasonable grounds and in accordance with fair procedures established by law, is not so far removed, if at all it is, from the qualifying section 7 of the Canadian Charter, except in accordance with the principles of fundamental justice. Principles of fundamental justice must include reasonableness as well as substantive and procedural fairness, which is recognized. And there the court, even in referring to section 14 and quoting the words except on reasonable grounds and in accordance with fair procedures established by law, completely ignores what follows those words, which are distinct provisions dealing with due process. The view of the full court was that the right to liberty in section 13.3a reflected the right to personal liberty as taken from the European Convention, as considered in Engels and Netherlands and Guzzardi versus Italy. They stated that at page 212, paragraph 216. Page 216. The full court found that the regime engaged the attorney's liberty interests as a failure to comply with the relevant statutory provisions and regulations constitute offenses for which the attorney, if convicted, may be imprisoned. That's at paragraph 276, page 215. However, ultimately, the full court found that the obligations generated and the offenses created in support of those obligations by the impute provisions are appropriate, and the requirements of due process in proof of their breach are adequate. Therefore, the enforcement of the regime was not arbitrary, was based on legal certainty, and did not infringe the attorney's constitutional liberty rights. And that is at paragraph 299 to 300, pages 224 to 225, 244, I'm so sorry, to 255, and paragraph 372, which is at page 253. The full court went on to carry out a similar analysis with respect to the liberty rights of clients and found that for the same reasons, the liberty interests of clients, though engaged, was not infringed in a manner that was unconstitutional. And that's paragraph 308, page 228, and their conclusion, paragraph 372, page 253. The full court expressly found that the Canadian jurisprudence on section 7 of the Canadian Charter could not be directly applied to the interpretation of the Jamaican Charter, and that it would be accordingly erroneous to read into the Jamaican provisions the principles of fundamental justice taken from the Canadian Charter. That's at paragraphs 298 to 299. And in our case, we have pointed out one obvious difference between the Jamaican provisions and the Canadian Charter, which is that in the Canadian Charter, there is no express protection for privacy. Similarly, there are some New Zealand cases cited. There is no express provision in the New Zealand Charter for protection of privacy. That is contrary to those charters that is expressly dealt with in section 13(3)(j)(2) and 3. That's an important distinction. So in Canada, they have adopted a broad approach to liberty and to search and seizure to protect privacy rights. There is no necessity for that in the Jamaican Charter, particularly when you have to do violence to the words of the Charter, because those rights find express treatment and protection in the Jamaican Charter. So there was a comment by the Court of Appeal, and this seems to have heavily influenced their reasoning, that in the Jamaican Charter, there are no lesser rights conferred than that of the Canadian Charter. And that is true, but it's done in a different way by express language in the Jamaican Charter. So, you will see that while ostensibly agreeing with the full court that the Canadian principles of fundamental justice could not be read into the Jamaican Charter, the Court of Appeal nevertheless took the approach that the rights given by the Jamaican Charter should mirror that of Canada. Thus, they accept the conclusion of the full court that there is no need to transpose the qualifier in section 7, except in accordance with principles of fundamental justice, into the analysis of section 13(3)(a), that is at paragraph 307 of the full court's judgment. But by the end of their analysis, at paragraph 329 to 330, which is at 488 over to 489, they conclude that the Jamaican constitutional framework offers no less protection than the Canadian Charter. Accordingly, the liberty right in the Jamaican Charter is not limited to physical restraint and is not fundamentally different or so far removed from the Canadian Charter. Further, as found by the court, the restriction on liberty in Jamaica must be on reasonable grounds and must be in accordance with fair procedures established by law, just as it must be in accordance with principles of fundamental justice in Canada. It was noted in the decision of the board in Suraj versus the Attorney General of Trinidad and Tobago, paragraph 65, page 6632 of the bundle. In contrasting the Canadian Bill of Rights, which is now the Canadian Charter, to that of the Trinidad Constitution, that the Canadian Charter operates in a different way and with different force and effect from the provisions in constitutions, such as Trinidad, and we submit such as in Jamaica.
Could you just give me that page number again?
6632.
Thank you.
Paragraph 65. And that difference is both in respect of the words used when you contrast the language of the respective constitutions. But also, there is an important difference in the operation of the Canadian Charter, which is to be found at section 33 of the Canadian Charter, which is at in a supplementary bundle, page 10, which permits federal and provincial legislatures by ordinary legislation to override the provisions of the Canadian Charter, section 7 to 15, for a period of 5 years, and that can be extended for further periods of 5 years. So by simple, ordinary legislation, any provincial parliament can opt out of the provisions of section 7 to 15 of the Charter. Section 7 being the liberty provision. And the principles of fundamental justice. So we submit that the analysis that the Court of Appeal went through to, in effect, import Section 7 rights into the liberty rights in Section 13(3)(a) was wrong. And quite frankly, we submit unworkable. Because if the first limb of Section 13(3)(a) is a distinct right, that being the right to life, liberty, and security of the person, and it is the same right dealt with in what they say is a second right, the right not to be deprived thereof, except in execution of the sentence of the court. Then if liberty is construed as freedom of privacy, then on the wording of that second limb of Section 13(3)(a), a person has a right not to be deprived of privacy, save in execution of the sentence of a court in respect of a criminal offense of which a person has been convicted. That is an unworkable arrangement whereby any legislative or administrative interference with privacy would prima facie require judicial oversight and the application of due process leading to a conviction and sentence of the court. And if liberty is as broad as construed by the Court of Appeal in that first limb, it also includes the myriad of other rights articulated in Section 13(3). It seems that the Court of Appeal's solution to this conundrum was to construe this section as conferring duplicate rights, which we understood from the reading of the judgment to be a wider right in the first limb and a narrow right in the second limb. And presumably liberty in the first limb is broader in meaning than liberty in the second limb, being the right not to be deprived thereof, save in execution of a sentence of the court. In effect, by giving liberty these differing meanings and as the court said, the triplet of rights, the qualifying Section 13(3)(a), save in execution of a sentence of the court in respect of a criminal offense, also presumably doesn't apply to the first limb, that broader right. We submit that the interpretation of the Court of Appeal is confusing It's not supported by the language of the provisions of the Jamaican Constitution. It's not supported by the scheme of Section 13.3. And the court failed in looking at the interpretation of the Constitution to look at the words to be found in the text, and the same word ought to bear the same meaning. How can you construe liberty in any limit of Section 13.3a as separate from liberty in Section 14, for example? The provisions are to be read as a whole, and we submit what you see in the judgment is the court reading into the Constitution its own, we submit, moral values and predilections.
Well, Mr. Wood, is that a convenient moment?
If this is a convenient time, I will continue after lunch with looking briefly at the provision in the Constitution dealing with search, and I regret to advise that this case was found after we settled our case. It's the decision of Newbold versus the police commissioner, which deals with search, at page 310, and we refer specifically to paragraphs 24 to 26 at 325, 4325 to 4326, where we say again, our Constitution is not as broad as that of Canada when it comes to the interpretation of that provision.
Yes. Well, we'll resume it.
Thank you.